Hi, my name is Andrew Kinney. I'm an attorney at Hoglund Law Offices. I have with us today another Social Security attorney, Bo Chin. I wanted to talk to him a little bit about his clients and also about the process to apply and get to a Social Security hearing. How are you doing today, Bo?
I'm good, Andrew. Thank you.
You sign up people, right?
I do.
Okay, so you see people on the front end. Are there any sort of things that seem to be stressing them out that you're helping them with on the front end?
Well, to be honest, Andrew, I believe most people in general don't have any idea about the process, any idea on time, any idea on approval rate, chances of approval, when they think they can get that approved. Usually they all have a friend or a family member that have told them something, or they heard something about Social Security.
Is that always accurate, what they heard?
Usually is not. It usually is not accurate, and there's some doozies out there, but I understand how things go around.
Sure.
You know, people are really concerned with the time frame. The time frame of these Social Security claims can get drug out, especially if you get denied at the first two levels and have to go all the way to hearing. A lot of people are concerned with what to do in the meantime, based on what they can do to survive financially.
Sure.
They're usually concerned with what kind of programs are available, or if Social Security is willing to do anything for them in the meantime.
What about getting treatment for health care? Is that something you talk to them about?
I do, absolutely. Treatment's very important with the Social Security case. They, you know, you can be the most disabled person in the world, but if it's not documented and well documented, your approval chances of approval are slim.
So what if you have a problem, let's say migraines or something that they can't help you with? Does Social Security assume that you're fine if you don't go and get at least some form of care over time?
I think there's, you know, I don't know if they would assume you're fine, but I think that that is going to be the way they're swaying. You definitely need to have some type of record. Now, do you have to go every day, all day for a migraine? Maybe not. I like to tell a lot of my clients that in a migraine situation or in a seizure situation, if it's a smaller seizure that they're not requiring hospitalization, I like to tell them to keep a log, keep a journal. Date, time, what happened, how long it lasted, and I think, and I have seen that judges appreciate that. It's just another form of documentation to recall how often you're really having these problems.
And that could help someone with their own physician to know how frequently things are happening. And so keeping track of your own health, it needs to keep going on, especially if you're eventually, let's say, go to a hearing. Now, let's say someone's applied, they get denied, they're at reconsideration, they're denied, then they get to a hearing. Roughly how long can that time frame be in your experience?
In my experience in Ohio, I'm mostly working out of Ohio, the Columbus and Dayton offices. Throughout Ohio, though, I think if you call Social Security, they're going to tell you from beginning to end, application all the way to hearing is going to be well over 2 years. In my experience, it's right around the 24, 26, 28 month mark.
Okay.
I would say 2 years, a little over 2 years, is pretty normal. At least right now with the dockets.
So you help people on the front end. You also help people at hearings.
Correct.
So what do you tell people when they're nearing a hearing?
Well, nearing the hearing, obviously they've been waiting a while at that point, up to 2 years or so, or more. They're concerned. They're obviously very nervous. We do hearings all the time as the attorneys with this firm. We're at the hearing office every day. I try to kind of ease their mind. Everybody's stressed out. They're worried. They've seen every lawyer show on TV, and they see what they think courts or hearings are. So I try to explain them, you know, what they can expect. You know, we know what questions are going to be asked by the judge. There can be experts in the hearing room. We know what questions are going to come up with the vocational expert or even the medical expert, just by the file and the record and our experience being there. And you know, we get to know these judges. They're not new judges to us. We know what to expect from that judge, how they like to question the claimant, how they like to question the attorney. And I try to lay it out from beginning to end to let them know exactly what's going to go on, just to calm them down, not only for their sake, you know, at ease, but also to help them do better, perform better in the hearing.
Also know what to expect. Is there a perfect way to answer questions at a hearing, or is it better to just know what to expect?
You know, I think it's better to know what to expect. I mean, there's no way to script a hearing because you don't really know how the judge is going to ask what questions in what order. You can predict what's going to be important. There are certain judges that like to ask certain questions, as you're well aware, that you can kind of help them prepare. But, you know, my advice to every client is be honest. Do your best. Answer the question when you're asked. If you don't understand something, that's okay. The judge will explain it, or give me an opportunity to explain what's going on.
It's not a test.
Sure, absolutely not. And if you're telling the truth, there's not a wrong answer.
And sometimes I tell clients, you're not proving anything. Your records prove it.
Right.
You're there to explain your day-to-day. Does that make sense?
Absolutely. And that's another thing, is because they feel like it's all riding on the hearing. And the hearing is very important. You know, it is very important. However, the records are still in the file. the judge is still going to review the records. It's not just, well, the client forgot to mention this, we lose. That's not how it goes down. The hearing's important, but the records are what's proving the case.
So a good relationship with your medical providers is helpful because they need to know your symptoms, because ultimately you go to a hearing and a judge and you are looking at the medical records.
Absolutely.
So it's important to treat whenever
it's
possible.
Important to treat. It's important that if you are having a problem, make sure you're telling your doctor. Make sure you're telling your specialist, your surgeon, your family doctor. It needs to be in the record, because if we're bringing it up to the judge for the first time, it doesn't hold a lot of credibility or weight, for that matter, because they've never seen it. If there's a medical expert reviewing the case, they've never seen it. We can't take everybody's word for it, or everybody would be on disability at that point.
That makes sense. Thank you, Bo, very much for talking to us today. If you have further questions about Social Security benefits, perhaps you want us to help you, you can call the number at the bottom of the screen. You can also go to hoglundlaw.com at HOGLUND.com. Thank you very much.
Thanks.